Yeah, we'll be starting now. And so at this junction, I would like to hand over to the moderator. His name is David Ode, and he is the best graduating student of Enugu campus. So he's going to be a panelist as well as a moderator. So stay tuned. We have a lot of people here who are here to give you value. And so I'll leave the introduction to David Ode. And once again, for those who were not here at the beginning, my name is Tolulope Awoyemi, and I'm the founder of Young VIP TV. So enough about me at this junction. So let's get right into it. So David, I will be handing over to you at this time. So
Hi, Tolu. I don't know whether to say good morning, good evening, good afternoon, but to you and to every other person joining from different time zones, good day. And thanks for that wonderful introduction and also for putting this together. So I think this is very timely because for me and for some other persons that wrote bar finals last year, 9th of November is an important date for us. On this day last year, we concluded our bar exams, and I can see Miriam, I can see Daniela, some persons that were called alongside myself. And I mean, having this session at this particular time is just, it couldn't have come at a better time. And also for students that are preparing to take the bar exam next month and in subsequent years, next year and the like. So in this session, we have like arguably the best of the best from the main set, the regular set, and the backlog set. And our speakers are just amazing. So we have Vanessa. Vanessa was the best student in criminal litigation and also the third best graduating student in the backlog set. We have Tommy Singh. Tommy Singh was third best in corporate law and second overall best graduating student in the backlog set. We have Daniela. Daniela, very popular, once a BGS, always a BGS. Daniela was best in civil litigation and third best graduating student of the regular set, that's those called in July. We have Miriam. Miriam was best in corporate law practice and overall second best graduating student of the main set. And then, more like saving the best for the last, we have Benedict Ate. Benedict garnered so many awards, in fact. 20, 30, Benedict will clarify when he speaks. Benedict was best in property law practice, best in professional ethics and skills, and the overall best graduating student backlog set. And then you have me. I was the second best in prof ethics and the best male of Enugu campus. So it's really going to be a session where you get to learn what we did, how to write bar finals. I'm here with my notepad to also learn. I mean, I may not be taking the Nigerian bar exam ever again, but who knows? Some of the tips that I'll learn here will be relevant when I sit for the New York bar by God's grace. So I don't know, I can't see Vanessa. If you're here, I'd like you to go first. Just confirm if you're on this call. Okay. Then Tommy Singh.
Yes, I can hear you.
Okay, great. So Tommy Singh, I'll just hand this over to you to take us through your session on how to answer bar finals. You have about 13 to 15 minutes for your presentation. Over to you, and thanks for agreeing to do this for us.
All right. Good evening, everyone. Good evening, David. Thank you for the opportunity and the warm welcome. So without wasting further time, I mean, we have a lot of scholars here and, that will be sharing tips on how to answer the bar final question. So I'll just him. Sorry, can you hear me? Okay. Sorry, can you hear me? I'm not getting a response.
Yes, I can hear you.
Yes, I can hear you.
All right, thank you very much. Thank you. I just wanted to be sure that I wasn't talking to myself. Thank you very much. So without wasting further time, I will just go straight to the point. So I'll be starting with how to approach MCQs. So basically, bar finals is divided into two. We have the MCQs and then we have the theory aspect of bar finals. So the MCQs is usually the first exam that we write, and it's about an hour, 100 questions basically. So I'll just be sharing a few tips on how to answer MCQs. And for me, I think MCQs are very important in the grand scheme of things. One of the things I did personally was that I practiced MCQs over and over, and my logic behind it was that I know it's not possible to get, I don't think it's possible to probably get full marks in the theory, like 80 over 80, but I think it's very possible to get 20 marks in your MCQs. And I think if you can get 20 marks, if you are a student that is above average generally, you should be able to say to yourself that getting 50 over 80 is not really that difficult. If I can get 20, let's say worst case scenario, I don't get up to 20, I get maybe 15 or 16. Getting 55, it's not really difficult like that. So I think that's the logic behind preparing very well for MCQs. And I think MCQs is probably one of the easiest ways to get the first class because you've already gotten good marks there, and you just need to build on that in the theory. So quickly, how to approach MCQs. So the first thing I would say is do not spend more than 10 minutes on a course. MCQ is probably the fastest exam you'd ever write, and the way time flies is so insane. So you just want to you want to be sure that you finish before the time is up, and you want to be sure that you attempted every course. So I would advise you not to spend more than 10 minutes on a course. Now, if you practiced repeatedly, it will not be so much of an issue. So that's the first thing I'll start by saying: do not spend more than 10 minutes on a course. If for any reason you are not done with a particular maybe you started because it's usually civil litigation first. So if for any reason you are not done and then 10 minutes is up, I would advise you to move to the next course and just attempt it. Then you have 10 minutes left after you are done. You can always use that to finish, but you don't want a scenario whereby you finished 4 questions and then the last one you probably just did 4 or 5 out of it. That's if you're not a very fast person. So you want to ensure that you kind of spread the risk. So that's why I would say you should not spend more than 10 minutes on a course. Then secondly, for scenario-based questions, now in MCQs you see a lot of scenario-based questions whereby they will give you a scenario and then they will not ask you questions based on those scenario. I would advise you to, before, if possible, even before reading the scenario, you go through the questions quickly, then you read the scenario and then go through the questions one by one again. Now, alternative, this is what I did personally. I would read the scenario first, then go through the questions, then read the scenario again, and then answer the question. I gave the first one because of limited time. So if peradventure, because of time, you don't want to, you can just quickly go through the questions first. So you have an idea of what the question is asking. So when you are reading this scenario, you already have like an idea of what it is they want to ask you. And then you now use that to answer the questions when you are reading the questions the second time. But if you are fast, like I tried to be during the bar finals, I would advise that you read the scenario, then you go through the questions, then you read the scenario again, and then you now try to answer the questions this time around. Then the next thing for similar questions. So how do you answer similar questions? So especially questions that they have very similar answers. How do you answer it? You would have to pay rapt attention to the questions, trying to read in between the lines. You might have to read it over and over again, because they cannot be two answers. That's the truth. So they may be very similar answers. So you just have to pay rapt attention, reading in between the lines, and don't just see A and then choose the answer. You have to go check what B, C, or D is. A may look like the answer, but they may just be a more correct answer in C or D. So you have to pay rapt attention to the questions and read in between the lines. So next slide, please. All right, thank you. So also try to pay attention to like the differences in the various laws and states. So for example, that law school kind of has, for criminal litigation, we have the ACJL Lagos, the ACJL Kano, and the AGJA. So depending on the state where, so basically you can see a scenario that says something about the fact that something happened in Abuja. Now, if it happened in Abuja, you know that the ACJL is not applicable. The ACJL Lagos is not applicable, the ACJL Kano. So you have to be very careful. So when you're reading this, an answer may look correct, but that it will only be correct if the scenario was based in Lagos. Meanwhile, according to the question, it happened in how would I put it? It happened in Abuja. So basically, you have to note the differences in the laws and the states. So if a scenario is based in Abuja, you need to be careful not to apply the laws that are applicable to Lagos. The same thing applies for for property law. That's the PCL, the Conveyancing Act. You want to be sure that you are applying the right law to the right state when reading your questions. So when you are reading the questions, These are some of the things you need to look at. It happened in Lagos, not Abuja. So the rule applicable in Lagos may not be the same applicable. The rule applicable in the north may not be what is applicable. So you want to be very sure. That's why you cannot. There was something someone was saying. I think when we had our pre-bar, then there was an issue. Many people did not really finish the MCQs, and so I was the highest in that pre-bar. I think highest or second highest, I can't remember. The general one, I was, but for the one that class one did, I was the highest. And a lot of persons came to me like, how were you able to finish before the time was up? And they were like, did you read the scenarios? I said, I read the scenarios. Some of them were saying something like, for in the exam, they may have to just answer the question before without reading the scenario. I'm like, that is risky because sometimes that scenario may be in a different location and you don't want to choose an answer that would ordinarily have been correct if it was in the state you imagined in your head. So you don't want to make that mistake. So pay attention to differences in laws and states. Then if you are unsure about an answer, you should asterisk the question on your question paper, just like mark it and then shade what you think is the probable answer and then revisit it later. Because of MCQs is very fast. It's a very fast exam and you may leave space and then you say you'll come back to it later, but then you find that you don't have enough time to come back to it. And so just shade an answer. You just may be correct. So shade an answer, then asterisk it in your question paper that you would come back to it when you are done with the others. So don't just leave it. Just if you are going through, maybe you knew number 1 to 7, and then you go to number 8, you are not sure of the answer. Don't just leave it blank and say, I'll come back to it later. Shade something there, whatever you think the probable answer may be, just shade something and then asterisk it on your question paper and then revisit it later. Then, yeah, so that's it. Then the next thing I would say is if you are still unsure about the answer after revisiting it, then this is where you have to trust your intuition, basically, because you may not be 100% sure about all the answers, but then you now have to trust your intuition that, okay, I've read this thing. What do I think the right answer may be? That's just basically it. You just have to, so a time comes where for few questions, you have to trust your intuition. So maybe out of like 100 questions in total, for like maybe 5 to 6 questions, you may have to trust your intuition because you're not perfect, right? So chances are that you may not be sure of a few answers. And so you just want to trust your intuition that, okay, this is what I think. But as much as possible, do not leave any question blank. You don't want to make that mistake of, thinking that, I wish I just make sure that you shade something very important. You just have to shade something. So if you are not sure of it, you trust it. I mean, because of time, I cannot begin to give, I think it was in criminal litigation where they asked some questions like that. Criminal litigation was supposed to be the simplest exam in my head because when I was practicing past questions, that was when I usually get the highest marks in most. But surprisingly, it kind of seemed to be the most confusing for me during the MCQs. So I just had to trust my intuition for like 2 or 3 of the answers. Like, okay, I think this is what the answer is. And then I just went with it like that after revisiting it. So initially I shaded an answer, then I asterisked it on my question paper that I'll come back. And then I came back and I was still not sure of like 1 or 2 of the answers. So I just had to, trust my intuition. And, thankfully everything, something, you just have to choose an answer basically. So please, next slide. Next slide, please. Okay, thank you. So concluding on how to answer MC. Okay, please next. Okay, yeah, okay. So some persons use bio. Okay, yeah. Please, the one before that, yeah. Okay, that's it. Yeah. In conclusion, please. Okay, yeah, that's it. In conclusion, be time conscious. It is said that MCQs, is the fastest exam you would ever write, and that's because of how quickly time flies. You cannot afford not to finish or worse to not attempt an entire course. Do not spend more than 10 minutes on each course, and I recommend practicing past questions under exam conditions. You don't practice MCQs by reading the questions and answering them in your head. You need to get the OMR sheet and a pencil and practice over and over. Then please, can you go back to that one that you were showing me before? Yeah, I think that's the next one. Yeah, okay, yeah. Some persons use Biro and book to practice MCQs. That's not effective enough. Shading takes more time than writing out the answer. So that's why you need to put yourself under exam conditions to see how fast you can answer the question. Speed and accuracy are equally important to acing the MCQs. So what I'm just trying to say here is that you have to actually practice under exam conditions. So, when we are preparing for bar finals, there was a style that many of our colleagues used, which is okay, but I just think it may not be that effective enough. You're just reading the MCQs and then you're just answering it in your head. And some people are using Pyro, like, number 1A, number 2B. That can work, right? But in the exam, you are not going to write, you are going to shade. And shading, from experience, shading takes time than writing. When you're writing, you're just writing A, but when you are shading, you are careful You don't want to shade outside the circle. You don't want to, so you are trying to shade very clearly and all that, and it takes longer. I didn't realize this early enough until after I came back from externship, and then we had one pre-ban, and I realized how slow I was in shading. Because prior to that time, I was always writing with biro during externship, before externship, and then when we had that pre-ban exam, and usually I would finish 100 questions in 40, 45 minutes at the time. But when I was doing that pre-ban, it took me about 53 minutes thereabouts to finish, and then I realized that, okay, I think I'm slower shading. So I had to start practicing over and over again. And in exam, you are going to be more careful than normal, right? Usually when you're practicing past question, you're just, whatever the answer is, you're not really, you are trying to shade the correct answer. You're trying to, choose the correct answer, obviously, but there's no pressure in the sense that, even if you miss a question, you're just going to check the answer when you're done. But in exam, you have to get it right. So most times you have to think again. So you want to put yourself under that exam condition early enough by shading. And so not just answering it in your head, reading it and then answering it. I remember the nights before my bar finals, I still did like 6 different past questions in the space of like, I think 3 hours thereabout, just trying to shade and just practice over and over again. Because you want to put yourself under that control, but you know that I am ready for this exam. Speed and accuracy are equally important, right? Not just enough to know the answers. You have to be very fast in the exam, or you have to be really fast. And so practicing this repeatedly before the bar finals will help you, know how your strengths are. So I'd encourage you to practice under exam conditions. So please, next slide. Next slide, please. Okay, how to answer questions. Thank you. So first of all, I'll start by saying that there is no universal method of answering bar finals, right? Irrespective of the questions properly, and that you give a sufficient explanation while answering your question. So that shows the examiner that you know what you are writing. So there is no one. Some people use the press rule. Some people use the Iraq rule that we use in the university. There are different methods, different styles. So like Yoruba would say, "Onokon waja." What that means is that it's not one way that leads to the market. So there's no one way of answering bar final questions. What just matters is that you get to answer the questions properly and that you give a sufficient explanation while answering your questions. I once had a scholar that said something, I think a first classman that said, in university we use IRAC.
Hi, Thomas, yes, we can hear you.
Yes, we can hear you.
Okay, I think I was disconnected for a moment. All right, thank you. Okay, so like I was saying, basically there is not one way of answering bar final question. I said something like, one of my seniors said, I think I did the first class, and it was like, in uni they use IRAC, in law school you use CCAC, like conclusion, rule, application, and conclusion again. Now, that is not 100, may not necessarily be 100% true, right? Everybody has different styles. So some people, whatever approach you use, the most important thing is that you give a sufficient explanation while answering your questions. Just want to let the examiner know that you know what you're writing. So here are a few tips that can help you excel in the bar finals. So next slide, please. All right, thank you. So first of all, I'll start by saying that you understand the question. So before answering the question, you have to ensure that you actually understand. I think a lot of people actually make a lot of mistakes from misunderstanding what the question is asking. So you have to take your time and actually understand that what is this? What are they actually asking me? And it applies not just to even theory, but like MCQs as well too. What exactly are they asking me to do? And this usually come from scenarios most times, because some scenarios can be very tricky and all that. Especially when they ask you to draft something and they didn't specify what you should draft. They said draft the first document that should, all those things. They're like, okay, what exactly is the first document I'm supposed to draft? So you have to pay rapt attention to the question to be sure that you understand what they're asking you to draft, basically. So for example, I think a good example where some of these confusions can arise is usually when it comes to notices to quit now, and then they ask you to draft maybe like a tenancy matter, and then they were like, you wanted to maybe like the landlord wanted to evict somebody, and then they're like, draft the first document, and then some people either mistake it for notice to quit or letter of instruction to the lawyer to draft. When you want to like serve a notice to quit, the first step is that the landlord is supposed to instruct the lawyer in writing. That's Koka and Aditayo, and then afterwards and all that. So sometimes they can ask you to draft the first document that the client should give the lawyer, but you can mistake it for the notice to quit itself. So you have to like read the scenario to know that, okay, are they asking me to draft a notice to quit, or they're asking me to draft a letter of instruction to my lawyer and all that. So that is one of the things that you kind of need to understand. So understand the question. You need to understand what exactly are they asking me to do. It usually comes out mostly in drafts, because sometimes they don't ask you to draft. They won't just tell you draft the resolution for something like, or draft this thing. They will just tell you draft. They may not be direct with what you should draft. So when you read the scenario very well, you understand that, okay, this is what they're asking me to draft. When it's like draft the first document, draft the last document. That kind of, for example, now Indeed, for example, now they can say draft the final document that both parties will. So you know that if it's for sale of land, the final document is a deed of assignment.
Okay. Yeah, Thomason, welcome back. We can hear you. So you stopped at, understanding the question. You can take it up from there.
Yeah, okay, thank you very much. So like I was saying, understanding the question, just have to pay attention to what they're asking you to actually do. So the next thing is, so for questions that has to do with commenting on the propriety or legality of the questions that has to do with like advising a person or giving your legal opinion, I think you can apply the press rule. So this was a principle that my lecturer, Mr. Dewan, who taught us civil litigation and professional ethics. So like point of view, then you state your opinion or your answer, then you give the reason why you hold this big view, then your evidence, you support your reasoning with statutory or judicial authority, and then summary. Basically, you conclude and you reiterate your points of view, basically. So next slide, let me give a practical example of how the press principle work, basically. So let's say you are given a scenario in corporate law where the managing director of a company removed the company secretary for no just cause, and then you're asked to comment on the propriety of the removal by the managing director. So like, here's an example of using the press rule to answer the question. So points of view. So you start by saying the removal of the company secretary by the managing director is improper. So then reason and evidence. So next slide, please. Next slide, please. Okay, the reason is because the power to remove the secretary of a company is vested on the board of directors and not the managing director. So then your evidence, section 331, section 333 sub 1 of the Company and Allied Matters Act. Then also the secretary of a public company can only be removed in line with the procedure set out under section 333 sub 2 and 3 of the Company and Allied Matters Act 2020. And then summary, therefore it was not proper for the managing director to have removed the company secretary. So basically what I just did there, this is just like a brief overview of how you can answer questions, especially in courses like civil ethics, sometimes corporate too, like that, where they ask you for commenting on the propriety, or let's say ask you to comment on the legality, or give your opinion. So basically just what starts by stating your point of view, it's proper. So I took this from a past question, I can't remember the exact year, that said something about that a managing director removed a company of a secretary, and it was a public company for no just cause, just remove that, and all that. So now, because it's a public company, you know that section 333, 333 or 331 provides for 333 basically provides for the procedure for removing the secretary of a public company. And in addition to that, section 333 also says that it is the board of directors that have the power to remove the secretary, not just the managing director alone, right? So it was the managing director that single-handedly removed her. So those are like two reasons why I now to give my reason. Number one, the reason is because the power to remove the secretary of the company is vested on the board of directors and not the managing director. Then I give section 333 sub 1, and then I went on to give the second reason. My point for doing I chose this scenario because there was more than one reason why I think it was not proper. So in those kind of scenarios, you have to ensure that you give. Now, I think what they are really looking for is that second part that says that the secretary of a public company can only be removed in line with the procedure set out under section 333. But also that first part also matters too. So when you answer your questions like this, you are displaying a very sufficient understanding of what you've been taught. So they know that this person knows what he's saying, basically. So that's what you want to do. You want to give the examiners an impression that you actually really understand what you've been taught. And that's like for property law and for other courses, whenever there are exceptions too, and as it relates to the scenario, you provide the exceptions in addition to the general principle as well too. So that is one thing you want to do. So the press rule is one way by which you can answer questions. I remember I said earlier on that there's no universal way, right? Some persons may try other when the other speakers come, they may give you a different approach to how they answer their questions. Then usually the summary, therefore, it's more or less like you are reiterating your point of view again and just restating what you said earlier on. So now let's move to the next slide. Okay, So this is another example again. Now, when you, for example, now you're asked to state the procedure for, I think there's supposed to be something before that, if I'm not mistaken. There should be something before that. Please, next. Okay. Okay, I think, okay, yeah. Okay. Okay, that's it. Okay, yeah. Okay, let me just explain this. So basically, let's say you are given another question that talks about stating the procedure, like states the procedure for this, list that. How you get to answer it is by just starting by, you give a preamble and then you go ahead. So for example, if they ask you to list the documents that are to be attached to a statement of claim in civil litigation, you don't just start number one, what's the list of witnesses and all those things that, or the document to be attached to a writ of summons rather, and then you start number one, statement of claim, number two, list of witnesses and all those things. You just start by saying the documents, you can just give a preamble, right? The documents to be attached to the writ of summons are as follows, number one, and then just give a preamble, right? You don't just want to don't just go direct, number one, statement of claim, number two, list of witnesses, number three, witnesses on oath, and all those things that you have to see. So here's another practical example. I'm using corporate law because I think that was where I received an award. So state the procedure for the registration of ABC Limited as a public company. So you give a preamble, like I said here. The procedure for registration of ABC Limited from a private company to a public company is as follows. Number one, Board of Directors of ABC Limited will pass a resolution proposing the registration. Number two, the Board of Directors will authorize the Secretary to issue a 21 days notice of general meeting to the members of AC Limited. You can also just say to members of the company. But I like to use the facts. I like to incorporate the questions into my answers, right? So if there is a name given there, I always like to use the name. So basically, since the question says state the procedure for registration of ABC Limited, I like to incorporate the names given in the question into my answers, because it just shows that you not just understand the question alone, that you not just understand the answers alone rather, but you also understand the question that was asked. So then thirdly, a general meeting is convened and the special resolution is passed approving the registration of ABC Limited, and so on and so forth, basically. So that is how to answer questions that has to do with stating the procedure, lists, all those things. They can ask what is the difference between a private company and a public company. You don't just have to say number one, a public company is the differences between a private company whenever you are asked to, enter that question basically before going into the answer proper. So thank you. Next slide, please. Next slide, please. Okay, always apply the facts when answering your question. Use the names given in the scenario. I already said that already when I was to understand the questions. Then also, as much as in them, right? Because I believe it's very easy to get full marks in draft, provided that you know the answers, right? So if you see maybe like two options, for me now, except for maybe corporate law, the other courses we did, I knew like 6 out of 6. So the issue was now which optional do I want to choose and all that. So I was now looking for, okay, where can I get more marks? Because I knew the answers to everything. So I was like, okay, where can I, which optional question should I choose that would be easier for me to kind of get full marks and all that? So I chose questions that has, one of the things I used as a guiding point to choosing was questions that had drafts in it, because, when you are given all these kind of questions that has to do with theory, like opinionated questions, different lecturers, someone, you can write something very well. One lecturer will mark it and give you, maybe it's 3 marks. Lecturer can give you your full 3 marks. Lecturer will look at it and give you 1.5. You may say, okay, maybe you did not give case, or maybe you did not write something, or you did not put something that you wanted to see. That's everybody has their different opinions, right? But for draft, once you draft it and you've gotten it, that's it. So for your optional questions, as much as possible, if you know it, if you don't know it, don't stress yourself. But if you know the draft, by all means, it may be long, but I would rather do drafts than do all those opinionated questions, as long as I know the draft. And except maybe you are extremely out of time, I know you cannot finish the draft before the time is up. But for me, as much as possible, I try to be very fast. And I remember my criminal litigation, the last, I think section B, I was about to choose, and then I looked at the draft. The draft was very long, but I was like, okay, I think if I'm fast, I'll be able to finish. And I was able to finish right on time, right? For corporate law 2, section A, I was able to, like, I think question 3 was full of draft, like 4 draft out of like 7 questions. And then section B didn't really have any drafts. Just know that answering section B might, shoot me in the leg and all that, and I may just end up making mistakes, and I don't want. So I just went for the draft in section 3. I had a lot of drafts, and I was able to do so well in it. So you want to actually like target drafts, basically. That is it. Then for property law and corporate law, it's advisable that you start by giving the position of the law first, then applying the position of the law to the question asked, and then you can conclude by stating your opinion of what you think the answer is. So I usually use the press rule for a lot of things, right? But I remember when we were writing our pre-bar exam, instead of just sometimes starting, but why not just start by giving the position of the law? Now, when the common law lecturer said it initially, I felt like I cannot change my method. This is very close to exam. But then, I mean, I was contributing it, but then the next day we're having our property law pre-bar, and the lecturer said the same thing again about, instead of just being direct at first, you might want to give the position of the law first, and then, especially for questions like, I think it applies more in property law, right? So just try to give that position of the law first, explain it well, and then after you've given the position of the law, then you now apply the position of the law to the question that was asked, like the facts, and then you now give your conclusion. So it's like a similar principle to that hierarchy, right? So I didn't give a practical scenario in the slides, but take for example, let's assume I just wrote something down here. It's not in the slides though. Take for example, they're asking you about something about mental capacity of a testator, and all that, and then you can start by saying something like the position of the law is that a testator must have mental capacity at the time of making the will and executing it. Okay, Lola and Boyle. However, where a testator had the mental capacity at the time of making the will, but lost the mental capacity at the time of executing the will, such will is valid if the following conditions are present. Then I went for that to give all those conditions, basically. I don't want to bore you with all those stories. Then I went for that to say, in this instance case, giving instruction, and instruction was given directly to the solicitor. And honorable, this person was even though he had no recollection of the content of the will at the time of executing the will, he understood his act, and therefore the ground that honorable ABC had no recollection of the content of the will at the time of executing the will is not valid. So basically, I just did that to like give you I think the other speakers will probably do more justice to that, especially those that are best in property. So what I just basically said was that when you are giving a question that has to do with sometimes giving your opinion or on something, especially for property law, because of how detailed property is, coupled with the exceptions and all that, you just want to state what the position of the law is, giving a full detail, like explain what the law says in detailed context, and then now apply it. You can see that the example I gave is not in the slides, but I try to give like a practical example of how applying the position of the law to the question. So usually for property law and sometimes corporate law, our advice is to be more detailed, right? Start by giving the position of the law. So even in cases where you're not sure of whether or not an action is proper or not, I feel like this method gives you an edge, because once you provide the correct position of the law, regardless of your opinion at the end of the day, you've gotten a reasonable number of marks, right? So that's basically it. So, but generally, I use the press rule more often, right? I try to state my opinion first, then I give the reason why I think the answer is, and I back it up with authorities if I have any authority, and then I summarize. Then for drafts, I did a lot of drafts, very important. Then for procedures, you give the preambles, and then for property law, majorly I had to use this method of giving the position of the law first, then applying the position of the law to the facts, and then giving a conclusion. So next slide, please, as I round up. Next slide. All right. So in conclusion, this is like the crux of everything, because I think that your handwriting at the end of the day might affect your performance, right? So no matter how, I mean, a lot of speakers are going to share with you tips on how to excel in the bar finals. If you have an handwriting that is not so legible, it might end up affecting. So be careful of your handwriting, no matter how brilliant your answers are. The examiners have to see it for them. You want to try to write slowly and carefully. I'm saying this because this was an issue for me personally. I don't have the best of handwriting. My handwriting is not so good, and I think it affected me in secondary school and university a lot. So going into Nigerian Law School, I knew from the beginning that if I was not going to get the first class, it might be because of my handwriting. Because teachers had always told me back then that sometimes you deserve better scores, but because they are not seeing what you're writing, so most times they just have to give you. So going into and it affected me, I think, in the university too, because my handwriting was terrible. Let me just use that word. So going into Nigerian Law School, I had to be careful of my handwriting. So you want to, if you know that your handwriting is not really nice, you might want to write slowly and carefully, because no matter how brilliant your answers are, if they can't see what you're writing, there's very little they can do. They're not going to give you a mark assuming that that's what you wrote, right? So you want to try to write legibly. You want to try to write as clearly as possible. It doesn't have to be fine. It just has to be legible, right? That's the most important thing. Just make sure they can see it. One thing I did personally was that I said something earlier on about practicing under exam conditions. So usually when I solve my past questions and then I go to show some of my friends that, please, can you see what I wrote? Can you see? And then, fine, it's not, the handwriting is not so fine, but can you just see it? And then most of them, they can see it, they can see it. So as long as they can see it, I'm fine. If they can see it, then obviously the examiner will see it and all that. And they are marking a lot of script at the same time. So you don't want to piss them off with a bad handwriting, right? So you just want to ensure that you give a very legible handwriting, regardless, may not be too fine, but just let it be legible, let it be bold. So as much as possible, I was kind of a bit slow when writing, especially in the theory, right? Because you want your writing to be very legible. So I think I've come to the end of my session. Thank you very much for the opportunity. I wish you the very best in your upcoming bar finals. Thank you very much for having me.
Well, thank you so much, Thomason. That was really, really value packed. Like, it was engaging, it was practical. You broke it down into swallowable muscles. You went down to every aspect. And the key takeaways for me are as follows. MCQ, Thomason told us how important time is. You should not exceed 10 minutes per course. I'd even say bring it down to, well, 10 minutes, yes, but I'll say try 8 minutes because you have 60 minutes for the entire exam. So time is important in your MCQs. And then bar finals is a test of speed and accuracy. You need those two hand in hand to go. So, and then practice. I cannot overemphasize the importance of practice with regard to bar finals. So, practice, shade your MCQs in OMR sheets. Don't just use biro and paper. And then for essay, there are different styles. Some persons will tell you use Scribe. Some persons will tell you use press rule. We'll get to even. I'm just hearing of this, the conclusion rule application conclusion method that Thomason mentioned. I'm just hearing of it today for the first time. Imagine even a year after I wrote bar finals. Drafts is just one way to earn your marks, because if you get the draft 5/5, nobody will take away anything from you. If you draft your charges correctly and charges carries 25 marks, you get your 25 marks. We'll hear subsequently from some of the other best performing students. And then, detailed answers. There's always that question of, when do I put the balance? And Thomason rightly even mentioned property law. When we wrote property law, I'm sure Daniela and Miriam that are here will maybe say something about this when they speak. Our property law, I was so confused as to, should my answer be short? Should my answer be long? Because I wrote the question on wills, question 4, it was a compulsory question. I had written bank and Goodfellows, but I just didn't know which answer was correct. I kept writing, and when I flipped over to the next page, I remembered what our lecturer said, if you have written up to a page, you are off point. I had to quickly go back and, reiterate the initial points that I started with, and then handwriting. Although you're writing fast, write legibly. So that was an exciting presentation from Thomason. And then up next, we hear from Daniela. Daniela was called to bar in July. She wrote the November 2024 bar exam. She was the best in civil litigation and the overall third best graduating student. I wonder how you guys do it. 7,000 persons wrote the bar exam and you are top 3. Daniela, we really want to know what you did and how participants today can, follow that lead and come out with awards. Over to you, Daniela.
Good evening, everyone.
Evening, Daniela. We can hear you. We can see you.
Okay, that's fine. So, I want to thank the first speaker for a very insightful speech. I think he did a very good breakdown from the beginning to the very end of his presentation. So I would just add to what he has said, right? And I don't know what the timing is. I was told 15 minutes. Is that still the case? David, please confirm.
Yes, that's still the case, Daniela. But
Okay.
I don't want to also restrict you for the benefit of our students. If you're going to exceed 15 minutes, well.
No, that's fine. I think the first speaker has done a very good job. So if anything, at most 20 minutes will be fine. So I'll stick to 15. So I'm going to start with the bar finals. And then along the way, I would chip in things that I remember preceding the bar finals. So please be attentive throughout. So how did I approach MCQ during the exam? I'll start with before. So before the exam, I had prepared extensively for the bar finals, in the sense that I had. So what I and my group of friends did was, when we came to law school, at the end of each day, we would take the topic for that day, would read it, and then they had this MCQ, what do you call this thing? This MCQ per topic questions. So what we would do is would answer those topics, and we were timing ourselves. So if a topic had 20 questions, we would have timed ourselves 10 minutes. So we were doing that from the very beginning, and that was how we continued until I think we went for externship and came back, and then we started using the actual what do you call it? Before we went for externship, we started using the actual shading. So with that shading, we would reduce the time. So when we saw that 10 minutes, we were getting used to 10 minutes, we started doing 8 minutes, started doing 7 minutes. And this is because it was not for the 100 questions. When we came back from externship, we started doing the general practice. And we found out that because we had been doing the 10 minutes and all of those things, we were spending max. The worst person was spending 45 to 50 minutes. But people that were so used to it were spending 30 minutes. Now, during externship, I had also improved on myself. I had the externship, the sheets, shading stuff. So on my own, I had done MCQs with. So my MCQ was so funny because I had done 2016 to 2023, and I had, when I say I was quite a jovial person and I was a group leader. So I had different people, different friends, and everybody wanted to just say, oh, Nana, let's do this MCQ. So I'll do with this batch 2016, 2023. I'll do another set of people 2016, 2023. By the time I was done, I'd done with like 5 different sets of people. So I'd done the MCQ back, back, front. I was also using the Law Paddy app at a point. So those things prepared me in terms of time management and in terms of accuracy, because there are 2 things that MCQs are testing: your accuracy and your speed. So I was able to utilize that. So when I came back after externship, I continued with the drill. So in nutshell, I had been preparing all the way from the beginning, but bit by bit. It was during externship that it intensified to actually like shading. So I think it's best to shade, because that's when you can identify like, okay, what am I struggling with? But if it's just writing, when you enter exam, or shading will be difficult. Now I know there are people who write the answers and then go back to shade. I don't recommend that, because you may not have that time to go back to shade. You have 100 questions to finish in an hour. By the time you finish writing the questions, 40 minutes may have been gone before you start shading. And that's the thing, there's the fear of making a mistake while you shade. So just avoid that. That's my own opinion. But if you've been working with that system and it works for you, I don't know if it's too late to change or if you just want to stick with it. What works for you is just the main way out. Now, during the exam, I had this, I mean, we all know this principle from childhood, that whenever you're answering a question that is timed, if you are struggling with a question, leave it and go to the next one. I also adopted that. So if I was in externship, if I was in MCQ all, and I'd spent a minute on a question and I couldn't make headway with that question, I would just asterisk it. Look for the answer that I think is the most recommended. So if I'm struggling with C and D, okay, if they were to ask me on the spot, which will you choose? Oh, it's C. I would just shade C tentatively and then asterisk it. Why am I shading C tentatively? Just in case I never get to go back. At least I shaded it and I didn't lose that mark. So if it's C, it works for me. If it's not C, at least I put something. I didn't just let the mark go. So that was my idea. Now, the first speaker said something very intense on this, which I agree with, and that's the fact that when you're doing your MCQ, you need to pay rapt attention to every single detail. See, it's when you're doing your MCQ you realize that A and A and D and all those plural singular, it can even be those. I'm exaggerating, but I'm trying to tell you how little an information it is that can change the course of your answer. I remember in our civil litigation for MCQ, there was a question towards the end that got people confused on matrimonial causes, how the exception of this will lead to this, and people were like, oh, if this exception, I can't really remember what it was, but I had shaded the wrong answer. And I remember that I just looked at the question again and said, no, there's something off here. And that was what drew my attention to it. So for questions, there are some questions that you don't even need to read 3 times. Looking at the question, you already know this is the answer. All you need to check is, are there exceptions? Is it Kano? Is it Lagos? Is it Abuja? Depending on the course, right? But there are some questions that you just have to look over. And you will now realize that what they're asking you is not even the exception, it's the exception of the exception that they are asking you. So those are the things I think you need to pay attention to. Now, as to how to read the scenario questions, me, I had a different approach. I read the question and then went to read the scenario. And this is why the question helps me identify things that I'm looking for, things that should increase my curiosity. The question, yes, increases my curiosity, but with the scenario increasing my curiosity, but with the question in mind, I'm extra intrigued by what I'm seeing. So if I'd seen a question that talked about something, let me say arrest, and in the scenario I'm seeing arrest, I'm underlining that part because it's matching, like the information are getting to match in my head. Now, when I look at that question, I look at the scenario, I go back to the question and say, okay, what is this? And what is in the scenario? And then click it together and then underline. So with my scenario questions, I just looked, and when I mean looked at the question, I don't mean I skimmed through the question. What's this question really looking for? Is it a what question, who question, location question, whatever it is that is answered, right? So that's it. Then what else? So I've already explained the strategies that helped me the most with my MCQs. How did I choose between similar options? I do elimination process with my MCQs in the sense that if I have 4 options and I see that, oh, all of them are looking alike, why is A not the answer? Why is B not the answer? So most times you focus on why is A the answer, and then you now see B, and then you're confused as to B is also the answer. But if you focus on why is A not the answer, you would see why you should eliminate it. I don't know. For me, it was a reverse psychology thing. So by the time you look at the whole 4 questions, by the time you start eliminating, you would come down to your final answer. And in what scenario, you come down to 2 good answers. And what I always did in that scenario was, why would I pick this over this? And if I can give, in law, we don't just say, oh, I'm picking A over B. What's your evidence? If I can give maybe a case law or something that I was said in class, or a section of the law that I know that supports why A should be it over B, I go with A. So that was how I attempted or approached my MCQs in bar finals. So I think I was done my MCQs by there's something in it, and then I started going over. And the thing is, with the asterisk, the major ones to go over. I'm not saying don't go over everything, but when you go over everything, the ones you can now spend extra minutes on. So, for example, I remember in property, there was one question that I kept on going back and forth. I'm very sure whoever marked my script was like, how many times did this girl erase this answer? But what helped me was, by the time I had gone, skimmed through everything, the last minute I had was I just looked at those questions that asterisk, because what it meant was that those were the questions that I had objections on. And so that allowed me focus my time on that. Now, the next thing is, how did I answer my theory questions? Every question has the way they answer them. Property is different from civil, is different from criminal, is different from what other courses are there? Prophetics, and then it's also different from corporate. So there's a way each lecturer wants you to answer everything, and if you have that in mind, it means that you should answer those questions accordingly. Now, is there anything special or those things so I used to use civil litigation because that was our first paper and it threw a lot of people off course. And I think our question 4 was on summary judgment. which is something they had never really asked as per a whole question or summary judgment. But for the Abuja own, they had asked the question, if I'm not mistaken, they had asked a question where they said, oh, what would have been what procedure would you have used to bring it before the court in Abuja? And the word was expeditiously. And I mean, there's summary judgment Lagos, there's summary judgment Abuja, but there's also undefended list in Abuja. So I don't remember the question very well, but I know that that's where people had a lot of, like, I remember a friend saying he had written the one for summary judgment before he now realized. I said, oh no, I don't think this is what they're asking. And then he now recalled and then did that. Because what happened was, from that question, I think that question was a C or D, from that question downwards, if you didn't get that question right, you had failed from that question downwards. And for a 25 marks question, I'm sorry to say, it's only God that can give you an A at that point. Do you get? So that was people's issue. So I think for me, it's a thing of read the question twice. Once you start having a second doubt about what a question means, it means that you need to actually pause and understand the question. There are some questions that I used to tell people, if you've read and you've gone through past questions, once you see the question, there's no hidden meaning. Like your lecturers, there's no hidden meaning. But there's some questions that even as you are reading it, your spirit will tell you, there's something here. So those kind of questions, I pay more attention to them, basically. Then the next thing is, so did I plan before answering? No. So for civil, I mean, I feel like everybody knows how each question should be answered. So because of that understanding of, okay, these are property should be answered, these are civil should be answered, I don't think there was need to plan. Because in my mind, I'm like, I don't even have that time. So start planning how to write. So if they ask you a question, will your answer be different if it was in Abuja? For civil, you just simple civil or criminal. No, my answer will not be different. This is because you put your case. It's that straightforward, right? But in property, they're asking you, is the lease valid? And then you have to start saying, if for a lease to be valid, there are 5 essential elements. You now list them and then say, okay, in the above scenario, there is certainty of property, there's certainty of this, there's certainty. So I didn't plan anything. I think that's another thing I would re-emphasize. If you had been practicing, so I and my friends, we are my different sets of friends, if I were to use that word. But majorly, I and my friends, we had gone over past questions 2016, 2023, minimum. That's the same group of friends 3 times. So, and every time we need to have past question practice, nobody answers you. The rule is you must answer the way you would have answered in bar finals. And this was something we did before externship. So when we do what do you call them? Pre-class tax and all of that, and they tell us how to answer questions. When we meet at the end of the day and we're answering a question, there's an expectation you are answering in line with how the question was asked, like how you would have answered in bar final. So from that way, we had already started training ourselves to answer in bar finals formats. But if I'm at the stage where you are now, is to go and find out what are the formats to use and then start, familiarizing myself with past questions and answering them. Another thing was, I and one of my friends, we answered questions. So we timed ourselves. When I mean answered, I'm not saying orally now. We timed ourselves and answered like writing. So I remember I timed myself for 2 hours, 30 minutes to answer prophetics, property, one year as a year set question in different in different courses. So for prophetics, for property. So by the time I had done that, I think, and I gave it to people who I felt, okay, these people would mark me very well and they would mark me good. So I remember that there was even a lecturer who had told me to go and do that and get back to her on it. And when she saw the outcome, she was like, okay, because she was scared that I was reading so much and I was going to overwrite. But when she saw the way I answered the question, she was really impressed and then gave me some corrections, right? So for me, that was even a good advantage because I was always complaining that I didn't feel like I was ready. And she was like, my issue is that you're over ready. And, because I'd done that practice and written it down, I think that also improved, made me more confident that, okay, I know what to write and how to write. And please, they had already emphasized it. So handwriting, it needs to be good. because it's something I've known from when I was small, right? If a lecturer is marking your script and your handwriting is bad, you are just stressing the lecture. So even if they want to give you mark, they can't see where to give it to you because they can't see what you're writing. But I'm not going to stress on that. I'm just going to focus on other things now. Did I use authorities? Yes, of course. I remember before externship, we had done snap test. And when they were marking the snap test, they were giving half mark. So you know that a question can have up to A to J as babies, A to F, A to G. And when I mean A to G, one of the B's, the B can have I and I, right? But I remember they had said for every part you give a case or a rule. So if A, you give a case, B, you give a case, that's half marks. And I remember then I knew a lot of cases and all of those things. But I remember I was marking someone's script where the person did not put cases. And it just dawned on me how this person had written so brilliantly and then lost about 7 to 10 marks because they didn't write cases. And I compared it with somebody who answered a few questions but wrote cases. And I was like, no, I am never going to make this mistake. So me from the very beginning, that's another thing I tell people at the earliest stage. All these things where you say, oh, I'm keeping my cases to learn them later, I'm keeping my section. It's not my style. Because I feel like by the time you are ready to learn it, your brain may have been fooled with so many things. Two is, if you start learning them from the beginning, repetition aids remembrance. So you would have repeated them so much and I knew almost all the sections in ACJA, ACGL, and Kano. I had a shot. Like I was not a fan of the police ads. I felt like when you don't have police art section, you still go back to Kano and ACGL. So you might as well just learn the three of them. So that was my own style. But what works for you is what happens, what matters. If you have a bad handwriting, please give space. Even if you have a good handwriting, when you feel like you're writing too much, you can give a bit of paragraphs and spaces. I remember I did that for Civo, but the issue was that it kind of affected me because my paper finished. And please, I know they say if you take extra sheet, it means you're writing rubbish. Please, if you think you need the extra sheet, take it. Because you can't write on your head, you still write on paper. So another thing I would say is I'm going to speak more to civil because I think that was what affected most of my mates, at least people I know, your drafts and your timing. And like I said, I'd already practiced with 2 hours, 30 minutes. So when I entered exam one, they told us 3 hours. It wasn't so much for me. But I remember like a lot of people left because we started our civil litigation by 4 p.m. and we didn't finish till like 7 or past 7. And I know that people left the all crying. Why? Because they didn't finish and they knew the answers. And it doesn't pay you if you know the answers and you don't finish. So try to manage your time, your drafts, be practicing them on that time. Like practice them very well on that time. So that way you can finish them on time. Then so managing your time between compulsory and optional. I didn't have anything specific, but I know that in the exam hall, I was led by the spirit to focus. So I had orders in which I wrote my exams. For civil, I remember the Holy Spirit told me to start from my compulsory. So I answered 4, 1, and 4, and then went back to answer my optionals. And I think it worked for me. But for property, is it property or corporate? I remember Holy Spirit telling me answer your compulsory optional, compulsory optional. So for me, I'm led. I work with the spirit, so that was the order. Well, I wasn't specific as to compulsory optional when I was entering exam hall, because my goal was not to miss mark in any. So whether compulsory optional, I was not playing with half a mark. I was so bent on that. What again? So I think I've answered that. So what are the common pitfalls and mistakes and final advice? I'm going to share something that I thought I would have learned from my Babcock University colleagues, but I'm sharing them here regardless. So I went to Babcock University where I graduated as BGS, and I think one of the struggles for me was Babcock cutoff mark was 8. So I have a cutoff mark of 80 to meet. And then we go to law school. And we go to law school, and then the cutoff mark is 70. So 70, 80. And I noticed that a lot of my colleagues, because most of my friends in law school were my friends from back home, and I noticed that the issue I had with them was that they were setting their goals with 70. And I was really angry. I have a friend who didn't make first class, and I feel like if she had done this, I mean, it's not a guarantee, but it would have helped. It's the way they say, shoot for the moons and I'll be shoot for the sun, whatever happens, you end at the moon. Please, if your cutoff is 70, I don't understand why you're aiming for 70. This is just me being serious. I feel like I don't want to be rude, and forgive me if I am, with all due respect. I feel like you're not aiming at all, because if you're aiming for a 70, it means that if you get 69 and a half, you've not gotten your goal. So, and you know that you are a human being where you make mistakes. So why don't you give that leverage for your mistakes? So for me in law school, maybe because I was also aiming for BTS, my goal was 100. At a point, my goal was 110. I don't know where the 10 marks were going to come from, but I had that mindset. And I don't know whether it helped, I don't know. But I was that zealous that I wasn't going to let half mark go. So I think that if you can solve that problem, I don't know if it's too late, but expanding your mind to aim for a 90 something, and worst case scenario, you end up on 70 or 75 or 80. At least you're still within your goal mark. Because they're getting even 75 is risky. But if you are 75, at least we see that you are trying to aim. But it's still risky. Why? Because you never can tell what happens in the exam hall. You can't tell if you make a mistake. You can't tell if, something can go off or you misinterpret a question. So why I'm saying think this matters, because when you aim for a 70, your response and someone aiming for a 90 or a 100 can never be the same, because you would let go of certain marks unknowingly, consciously or subconsciously. But that person aiming for 90 is conscious of every mark that is going and is getting. And I think that's one common pitfall that a lot of people make. Another pitfall a lot of people make is allow the fear become their reality. Like, remove your mind from the fact that it's overwhelming. Like, one thing I never did in law school, right, was never to look at the complete course compendium I had to read. Never. I take each day at a time. We're at this point, okay, what are we doing today? So the thing is, another thing was, I'm not the kind of person that reads before class. But what I did was, I was a group leader, so pre-class tasks, I was in charge of that. And so that was my way of reading before class. But generally, I think that we look at the whole, like, take a day at a time. When you look at the whole thing you have to do, you will just be so overwhelmed that you don't even know where to start. So, okay, I'm reading this topic today. That is all that concerns me. Tomorrow will take care of itself. I know it's easier said than done, but if you can focus your mind on what today requires of you, you would be able to focus on that and do it. Then another thing is time management. I think that the solution to time management is that you have been practicing. You can't be trying to draft a written address and affidavit for the first time in exam hall, and you think that you will not waste time. You would waste time. It's your first time. Basic. That's a good rhyme. But yeah, you will make time. You will waste time. Then another thing, one brief closing. Okay. So what would I give for you that are preparing? I think you're almost close to your exams. I really pray for the best for you, even though, I mean, I've reached out to some people have reached out, and I feel like, okay, the stage you are at, I expected more, but working with where you are, this is the advice I will give you. It's not too late to still hold on to that dream. Like, don't give up on that dream. Like, I know you think, Daniela, I've said all these things, but there's something I also know is that there's a God behind everything. And if there's anything I learned in law school, I'm still learning after law school, is that your works can do much, but God can do most. Your works can do much, but God can do most. So still keep that dream alive. identify areas that you are lagging behind. Oh, I'm not good in this course. And then set a target of how you can meet up. And when you are setting your target, realize that because of the limited time you have, your target will have to go more. So, for example, I have not read 5 topics in corporate law. Someone has read all the topics. If that person is reading 2 hours, I cannot be reading 2 hours. I have to be reading like 4 or 5 to cover up. So be able to give yourself that extra zeal. Another thing I always say is that some people don't get it. Okay, we know how much you want something by the effort you're putting into it. There are certain things I did in law school that even when I tell people, I realize how drastic those things are. But then it wasn't drastic because of how resilient and zealous I was for the goal I had set. Like I was so enveloped, engrossed, emaciated, like um I was so indebted to that goal that no matter what had happened, right, I wasn't going to take my eyes off that goal. So that kept me going. I used to say, like Jesus, who for the joy that was set before him endured the cross. This is your cross, endure it, but keep the goal ahead of you. What do you want? I had an image of my call to birthday, I had an image of the amount of words. And when it got tough, I would go to Young VIP TV and I would watch videos to remind myself. But if I was to say anything, is that you give it your very best, and that you are able to put in all that you can, even at this point. It's not too late to still get that goal. And I wanted to say something earlier, but I've forgotten. If I remember, I'll say it later. However, I think in a nutshell, right, preparing for MCQ and theory is not something you start now. But if you are starting now, I think you need to put in the efforts. You need to be serious about goal, and you need to you need to give it your very best from the beginning to the end. So if I was at this stage, or when I was at this stage, because by this time last year we had already started writing our exams. Today is what, ninth. Oh yeah, we finished the exam today. By this time last year. But if I was to, if my exam was to be next week, what will I be doing? I will take on my courses. I will analyze them as to strengths, weaknesses, where I am at. I mean, for me, I was already done with almost all the courses. The only course I think I still had struggle with was corporate, because that course was that course. But I would identify that. Another thing I would do is I would also, so I had my friends and we would sit down together and we would talk, we would take it topic by topic, we would analyze it, we would do past questions, we would do drills. Because another thing I used to say is that there's a point, law school, law school has different stages. The beginning stage for me was just reading, getting the content in. Along the line, I realized that there are other creative ways to read. And towards the exam period, I don't know, I think your exam is still about 3 weeks from now or two. But like towards the exam period, your brain has, depending on how you have read and your brain, this is read a lot. For me, my brain had already taken so much. And the goal was now, can I remember what I had taken? And that's what I was at. People say that when you enter exam mode, you will remember. I agree with them. But I also think that when they ask you question and you don't remember, not the ones you don't remember, and go and look at it. Because you will remember in exam more, but it may also take time and you need that time to write other things. So yeah, what I did was I had flashcards. So so the way flashcards is, your question is on the front, the answer is at the back. So once they ask the question, you answer. If you don't get it right, you check the back for the answer. So that helped with both the collection and ensuring that I go over what I had read. Then I had drills with my friends, both draft drills, all forms of drills. Then all this, there was a rule that my friend has. Once we say God, let it not come out. That's our sign that it's coming out. Like somebody just casually says, God, let it not come out. Go and read it because it's coming out. I don't know if it applies for you people, but I feel like that was God's indirect way of telling us, my dear, I brought this question for you to know that it will come out. So basically, I don't know if there's anything left for me to cover. I'm sorry, I'm in transit. but I think I have done a very good job answering MCQs and theory, and I hope I made it as practical as possible. So if you're at this stage, go back, do your MCQs, cover them, and another thing, be careful is some of these MCQs have wrong answers. So make sure that the one you're using has the right answer, or you know the right answer from exam hall, so you don't get to exam hall and then you're confused. Oh, this MCQ said this, but the lecturer said this. Whatever your lecturer says is fine now. Then if you've not done it, you can practice doing like an exam setting theory question. That gives you an idea. And when I mean exam setting, you're timing yourself, the hall is quiet, imagine the invigilator is in front of you. Once you can do that, I think it also helps you boosting your confidence and also makes you feel more prepared, because then you know your loopholes and things you can work on. But I think in a nutshell, that's it. Thank you very much. I spent more than 15 minutes. I'm sorry.
Thank you so much, Daniela. I mean, this was also power packed. And just to share from what Daniela said, about the importance of practicing your MCQs and reading your questions carefully. I recall the question she spoke about in civil litigation, MCQ. It was about matrimonial causes. And I lost 3 marks because of that question. I'd answered the MCQ, left, and then when we were preparing for essay, I now read matrimonial causes again. And when I read it, I was like, what did I now write in MCQ? And I quickly ran to my friend's room. I was like, have you read matrimonial causes again? And the two of us just started laughing because we knew we failed the 3 questions that followed. So it was like, they wanted to, I think, seek a dissolution of marriage, but it was they were just married within 2 years, and it was like an exception to an exception or something. So it's important to, read in between the lines. But I must also include a caveat. Don't overthink it. So especially you now go into the exam hall and you're thinking, what must be behind this question? Could it be an exception to an exception to an exception? Sometimes the question is just simply the general rule. And some other takeaways from Daniela. She said prepare from beginning. She started doing this even before externship. I can imagine that may not be practical for some persons, since bar finals is next month. But those persons going to law school next year, you now have the blueprint. Start preparing from, as quickly as possible. And it's also helpful to, answer past questions, give to someone to review. Daniela shared how she gave her answers rather to her lecturer. So you can even give your colleagues, your classmates in law school from other campuses, or you can even send to your mentors or other persons. So, just do all of that. And a very important factor, I'm glad that Daniela spoke about it, is the God factor. She said your work can do much, but God can do most. So don't keep away God. Keep God aside while pursuing your first class or prizes. Up next, we have Miriam. Miriam is the best in corporate law. And I mean, we're called on the same day. And when I was eager to know who would get this prize for best in corporate law, and when I saw Miriam, I was like, wow, like, how did you do it, Miriam? Really, I'm interested to know what you do, because corporate law is one course that everybody in law school is scared of, but it's by far one of the simplest courses or easiest courses. Miriam was the best in corporate law practice and the second best graduating student overall, number 2. Miriam, over to you, and we're really eager to, learn how to excel in bar finance. Thank
Hi, everyone. Please confirm that you can hear me.
you, Miriam. We can hear you. We can also see the slides.
All right. Thank you so much, David. So to answer your first question, right? You said, how did I do it? How did I become the best student in corporate law practice? Actually, I'm equally as shocked as many persons, right? Because corporate law was the toughest course for me in law school, right? It was something that I struggled with so much. So even if when I wrote my exams, so I kind of like had this inkling that I was going to have a first class. I also like predicted I was also going to get a course prize, right? But I did not, in my wildest dream, right, think it would be corporate law, not talk of being the best student in corporate law, right? So I'll just say that my fear for it pushed me into reading it so much. In fact, I read it more than I read any other course. If I read any course 2 times, best believe that I probably have read corporate law like 5 times. I was just going over and over and over. So to get into what we have here, I'll be talking to us about excelling at the bar finals, what worked for me, right? So my presentation is going to be it's going to be based primarily on my experience and what I learned, right, from them. So next slide, please. So as an introductory note, I'd like to say that, like most exams, right, the bar finals demand clarity of thought, precision, and an insane level of clear-headedness, right? It is grueling, it is stressful, but it is surely not undoable. If people before you have done it and excelled at it, your own case is not any different. So for any person who is probably having cold feet at this time, right, just know that it happened to the best of us, right? So it's just, it's just now when you're like out of that space, when you look back and you're like, oh, why was I fretting so much? Why was I so worried? I mean, it all turned out very well. But when you are in this, like, this period where tension is high, anxiety is high, is off the roof, right? So I'll just like want to tell you that bar finals is not something that is so, I know ordinarily when is not a misstatement to say that it is hard or that it is very, very demanding and challenging. That is very, very true. But then it is also not impossible to excel excellently or perfectly at it. So let's go to the next slide. Right. So the first thing I have here is how I approach MCQs in the bar finals. And the first item here is practice, practice, practice. If you've not been consistent before now, it is not too late to begin. I feel like MCQ is not something that you would know or you would do well at from just attending classes or from just reading your materials or textbooks or whatever it is that you read, right? It's something that you have to intentionally prepare for. And you can only prepare for MCQs by practicing it, because there's a whole lot that goes into it. You need to get yourself familiar with the style of questioning, right? So for those of us who are in law school, right, who would have practiced before now, and then sometimes when you practice and then you mark yourself, when you go back to then you score yourself, then you find out that okay, maybe out of 100 questions you are ending up with 70 something. So you go back to check what you have missed. Then you see that these questions that you have missed, it's not like you don't know them. There are things that if they wake you up from sleep, you can speak excellently to them. But then what happened in that moment was maybe because you were in a haste, or you just you overlooked some vital word or punctuation or anything like that, which has changed the question, right? So MCQ is something that you would want to familiarize yourself with. Apart from the fact that some questions are repeated, you also learn to identify the traps in each question. Yeah, so the second thing that I did was regulating my nervous system. This is very, very important because you need to be clear-headed to do your MCQ or even any exam at the bar finals. Is something that already there is pressure on ground. Even when you enter the hall, even for that time, I'm sure from now, the whole campus will be quiet. Any person who steps into the campus, even as an outsider, will probably know from now that something big is about to happen in a couple of weeks, right? So the tension in the air is already high. So what you can only do for yourself is to regulate your own nervous system, because it is only when you are calm and clear-headed you can interpret questions very well. You can identify traps, and then you don't make mistakes, like costly mistakes, right? So regulating your nervous system in this instance would mean that when you read a question at your first attempt, your head is clear enough to understand what is requiring from you. So if you're not clear-headed, you have to go over a question 2-3 times, you're not understanding it. So I'll give an example in this instance when I was doing my MCQ, before now, right, or before exams at all, I had already started practicing MCQs from like maybe the third week. I discovered this IECO material. I practiced it after every course. I was doing past questions. I did it repetitively, right? So I was, so even up to the point, I solved MCQ up to the point that I was preparing to go for my exams, right? I literally was still solving MCQ 1 hour to the exam. So I just dropped my pen, dressed up, and went to class, went to the hall. So from that time, I thought I already like perfected my time management. I was aiming to finish within 45 minutes at the most. So I would have 15 minutes to go over what is left, and then, just to do well. And then I was scoring myself. Then I was getting as high as 98 over 100. So my expectations were very, very high. So when I got to the exam hall and, I was seated, the first question from the way they arrange everything is civil litigation. So I remember that I did the first to 10th question, I was very confident in my answer. Then I saw a question that kind of like threw me off balance. This was on matrimonial courses. And then this topic is, I feel like everybody has been mentioning matrimonial courses. Daniela mentioned matrimonial courses. We had this problem because we were taught some days or some weeks to bar finals. They will tell you these fantastic 4 courses. When I talk about matrimonial courses, election petition, those topics came after our externship. So we had not had enough time to go over them too many times, like the earlier ones that they taught us for externship. So I saw a question on matrimonial courses. I was not really sure of what my answer was. Then I saw that the next 4 questions or 3 questions in that sequence were on the same matrimonial course. So it meant that if I could not answer the first one, then there was no way I could do the rest. So I had to I left it that I was going to go over it. So it was just a thing of, I'm seeing this question, I don't have the answer ready, like at my fingertips now. So I have to probably come back to, ruminate well. I'm seeing the next question is the same thing. I saw the next question the same thing. So it kind of like just triggered this panic, this thing in me. So I had to like just tell myself that, Mariam, calm down, right? So I was going to take that energy to maybe criminal litigation, corporate, because this thing is like it's like a spiral. From the onset, there is something that has already like triggered you. And then you're running on a 1 hour time frame, right? So it's just going to be like you may not really get yourself back in shape before time, right? So I had to like verbally tell myself to calm down. And I went to the next questions. So you would want to please regulate your nervous system. So the second one is time management. Time flies very fast in the exam hall, and I highly recommend going in with your own wristwatch, right? So I think this wristwatch thing has always been like my personal policy from university days. I can remember that even when back then, if we have an exam and then I forget my wristwatch, I have to look for someone to borrow me, because I was never going to go into a hall or an hall without a wristwatch. So and then, because you know that you have just 1 hour to answer 100 questions, you have to be fast and accurate. So you can like target 10 minutes per course, right? Even though I mentioned earlier that I was planning to spend 45 minutes, it did not happen like that in the hall. I ended up spending my exact 1 hour. In fact, if it was possible to beg for extra time, I would. So because you have to. No, okay. Now imagine that I had not like prepared myself to spend 45 minutes. Because even with all of my preparations, I was still exceeding the time that I targeted. So you just want to, not do that to yourself, and just have like a good time management plan in place. So the next is read and interpret every question carefully, right? So the thing about law school is that some questions may be simple on the surface, on their surface, but some may be much more deeper than that. So you need to train yourself to identify questions, to identify trap questions or traps in questions as quick as possible. So do not be in haste to pick answers without reading all the options, right? So the next is attend all courses. All of the courses are important. You would not want to spend 20 minutes on corporate and end up having to rush through professional ethics within 5 minutes or something like that. So as much as possible, then this is something like answer 10, 10, 10, 10. I did not do anything of such, right? Because I don't know. I just feel like if I've already set my brain to criminal litigation, let me just finish it before I switch to the next course. So whichever works. Next slide, please. Yeah, so how I approach theory questions. So like I said earlier, practice, 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 right? So if you've not started practicing before now, it is not too late. For me, past questions were like things that I used to regain, or I did past question like a sport. Let me just say something like that, right? So if I was stressed from normal reading, like from actual reading my notes, reading materials, past questions were just something like just to relax my brain. So something that I could do, maybe past questions while I'm on the go. I could do past questions mentally when I am not in a place where I can hold my book, right? So you have to practice questions, because the most important thing is that anybody can read, anybody has information, but what law school is looking at is how you answer these questions that they're giving you, right? Nobody's marking how many hours you've read, nobody's marking how many times you read a particular material, but how well can you answer this question? Right? So you have to, and the only way you can know this is when you practice, practice, practice. So then I have here time management, right? I had this strategy to use 35 minutes on compulsory questions and 30 minutes on optional question. Then the remaining minutes is distributed among your finished answers. Yeah, so for my theory exams, I just had it in mind that, okay, I was going to deal with the compulsory questions first, because for the optional question, I'd want to read through the 2 questions to know which one to pick. So let me just deal with the ones that I have no choice in, right? And I just get them and be done with. So I'll do 35 minutes, 35 minutes. Some questions will probably take you more than 35 minutes. So that's when, if you already have it in mind, you're going to spend 35 minutes and you've already timed yourself, you've calculated how long 35 minutes will be, right? So if you see that you are still, for myself, if I see that I'm still, I'm taking too much time on a particular question, I'll just leave it, go over to the next one. So the remaining minutes I have, I'd go back. So sometimes it could even be that it's not like I have not finished, but because maybe I still have some jara that I want to add, but I'd already like answered the questions, but there are still like some other things to add to make it more scholarly. So I'll leave some space and then come back to it. So it's very, very important that you do not end up spending 1 hour on question 1, because at the end of the day, no matter how beautifully you've written one question, you cannot get more than the allotted mark, right? So if they're giving you 25, they're giving you 25 marks for section, for question 1 and question 4, you can't get more than 25 marks, no matter, even if you are reproducing the entire comma in that question. So, sorry, are you following me?
Hi, Miriam. Yes, we are following you.
Okay. Thank you. Yeah, so the next item here is pause to think, right? Always have a mental sketch of the arrangement of your thoughts before you strike your hands or your answer booklet. So this is very, very important, because you want your answer to be like in a logical sequence. Sometimes when you are writing exams, you're under pressure, your thoughts can be disjointed, right? You're thinking A, your mind is already going to B, but you have to make your answer in a logical sequence, because you don't know the temperament of your examiner. He doesn't want to read A here and then he's seeing B at the bottom of the page, right? So just have this mental sketch. Always pause to reflect before you go into writing your answer. So then the next thing is underline or highlight any statement in the scenario that is given, that that it will impact or influence the eventual question at the end, or it will impact the trajectory of your answer. So this is particularly important for charges in criminal litigation. For me, I used to take a pencil to all of my exams, right? So if I see anything that I feel like I have to flag this, because this might probably influence the direction of the question. So I'm already underlining it then. So even if I'm going back to read the question again, I already have this one staring at me. Do you get? So for my charges, for instance, as I'm reading, I'm already underlining the parties, the names of the parties. If anybody has been mentioned to be deceased, I'll go back and cross it out. Do you get? So it makes your work easier, right? And then you do not lose out any important information. So then the next item is the style of questioning will determine the style of your answer, right? So I feel like Daniela and Tommy already said, every course has their own distinct style, right? So for civil litigation, for instance, you will not really need to do voluble answers. You not really need to write extensively because the questions are much. Most persons, when you ask them what their grudge is with their civil litigation, they'll say, oh, maybe because they were not able to finish on time. That's usually the problem because it's too much. I mean, I read somebody's story where this person said, she saw a civil litigation question. She saw a particular question that she was passionate about. So she just lost herself. She lost track of time and was, writing and writing. By the time, they would say time up or something like that, she realized that she still had like 3 sub questions that she had not answered. So, she left the hall. She was thinking, she was sad. But it still found out that she made a first class. So it meant that in that same civil litigation that she had already missed 3 sub questions, she still had an A. Right. So some questions like some courses like civil litigation or civil litigation in particular, your answers should be like direct to the point. Sometimes they'll ask you which court will have jurisdiction in this case. Just say the court that will have jurisdiction is the High Court of Lagos State. See this section. This is because the subject matter is contract, which falls within the jurisdiction. Just something around that style. You're already okay with that, right? Because it is much. Nobody expects you to be writing a full page on a particular sub question. But for maybe property law, for instance, I'm very sure for persons who are in Port Harcourt campus, for instance, okay, we before our lecturer was Mr. Kanu, or is Mr. Kanu. But then they brought Obi Okoye towards the end, right? He was just with us for the revision. He had not taught us anything prior. So I remember that when we were doing our pre-bar this thing, and we were answering the questions in class, and then they were like, okay, so who can read out their answer to a particular question? And then this person read it. Then people were like, it's okay. This one is ITK. This one is extra sheet. You don't need all of these things. And this man was like, this is what we want to see. Because sometimes the question may look like this is what they are asking. You just go straight to the point. But they want you to like go into corners that ordinarily they've not mentioned it like in the question. But then if you were to give like a full or an immersive answer to that question, you will talk about them. Right. So I know that for property law will require you to write extensively. You need to touch all the corners to earn your full mark. They want to be impressed, right? So for corporates, it depends on the question generally. Some of the questions, maybe lists mention the applicable laws. You already know. Once you've listed, you're getting your mark, right? Or then they're asking you to talk about the procedure. Okay, yeah, asking to talk about the procedure and all of that. Sorry, I'm running out of time. So basically, the style of questioning would determine the style of your answer. So next point is authorities are super important for extra mark. Like this is no brainer. Daniela already talked about that. Then the next item is that pick your battles or your questions wisely, right? So for optional questions, I had this practice of skimming through each of the questions before settling for one, right? And then the things the criteria that I use to pick which one to answer is not maybe which one do I know, right? It's not a matter of which one do I find more interesting to speak about. It is which one can I answer in this time frame and answer correctly, right? I don't know if it was Tommy or Daniela that mentioned that some questions you just have to be smart. If they're asking you to list, drafts, all of those ones, you can be sure that you may get your full mark in all of those ones. Or maybe if the question is asking you to comment, discuss, you are giving opinion, right? And your no two opinions may be the same. Sometimes your opinion may not align with the examiner. So the examiner may have the discretion to give you the full mark if he agrees with you, or to withdraw some mark. But then you still have to look at which ones can you answer within the time frame. So I give an example. So in our civil litigation exam, there was this section B. I know there was the two optional questions. There was one on election petition. I deliberately did not choose that question because I know, not because I couldn't draft a full petition in the exam, but I knew that under the limited hours that we had, it was not possible to do it well and earn my full mark. Do you get? So please, next slide. Yeah, so I have this model question and answer. Don't know if, okay, so we can see it, right? So you say Mr. Chidi is desirous of forming a company with his son Frank, who is 15 years old, right? And two of his friends, all of the subscribers are proposed to be directors of the company. Mr. Chidi wants to have control of the company and be the only director who will appoint other directors of the company. The company was eventually registered as Red Door Nigeria Limited by the lawyer. So the first board meeting is coming up on the 8th of November 2025. So now the question is, discuss the propriety of having Frank as a director and as a subscriber and as a director, right? So this is a two-linked question. So if you merge your answer together, you will lose mark. So you have to discuss the propriety of Frank being a subscriber separately. Then you go on to describe the propriety of Frank being a director separately. So I then already answered it here. So it is very proper for Frank, being a minor, to be a subscriber. This is because, it is always very important when they are asking you to discuss propriety or to comment on the validity. Your first answer should always be whether or not it is valid. So if you are agreeing that it is valid, you say it is valid. Because I remember that Mr. Khan used to tell us that for that statement alone, you're going to be getting a mark, particularly for criminal litigation, because you have questions like this more there. So yeah, so I believe you can see it, right? Can we go to next slide, please? Right, okay, so this is the second question. So I picked this one from a property law past question because of the peculiarity. So he's saying that Honorable Abu, a wealthy senator, had a ghastly motor accident on his way back from his village in Kaduna to Abuja. He was taken to an hospital, and after being stabilized, he called the solicitor, Maila Fia Ishako Esquire, and informed him that he wants to write his will. In this will, he appointed Alhaji Yusuf, his best friend, as his executor. Chief Ishaya, his personal assistant, and Binta Ismaila and Fatih's niece witnessed this will. So comments on the implication, the question is comment on the implication of the omission of a charging clause in the will, assuming Mailafia, Ishaku, and Alhaji Yusuf, an accountant, are the executors. So now on the surface of this now, at least for those of us who are in law school, we've already been taught charging clauses in will, and then the fact that generally as an executor, it is a labor of love. It's a gratuitous position. You're not expected to be paid, right? So there are exceptions. One of the exceptions is having a charging clause in that will. But then you also remember that there are other exceptions apart from this charging clause. So now my hint in this kind of question is that this question is deeper than it appears on the surface, right? It requires you to comment generally on the implication of omitting to insert a charging clause. So to answer this question, we first of all talk about the fact that being an executor is a labor of love, is a gratuitous position, not expected to be paid. That's the general law. Then there are exceptions. One of the exceptions is having a charging clause, then you go on to list the rest. Now, it also requires you to comment on the implications of Mailafia as a lawyer. If you remember that we've been told that Mailafia Ishaku is a lawyer, right? And then you also remember that there's an exception that says that if a lawyer is an executor, is entitled to be paid, right? I cannot remember the case, but I know it's a judicial authority on that principle. So you have to say this and then you distinguish it from the implications on Alhaji Yusuf, who is an accountant. So the fact that they put this accountant there because they want you to mention it's not just there for fancy. That's why I say property law questions are deep, right? So you need to lay that foundation. Then you talk about, because Melafia is a lawyer, he is entitled under this exception. But because this Alhaji Yusuf is an accountant, he is not entitled. So your answer is going to be in in that format. So let's go to the next slide, please. Right, so common mistakes and pitfalls. I'm sorry, I'm rushing now. The first is neglecting your health. Physical and mental burnouts are real, and even the best of us experience it, right? So law school is not a place that you want to be postponing going to the clinic or going to the health center. The thing about your body is that it will demand rest from you. It's not something that you can negotiate, no matter how much you delay it. But the most important thing is the most important thing, or the one you would not want to happen, is your body demanding rest from you in a time that you cannot afford it, right? So during bar finals, there'll be plenty persons who will be resting on the sick bed, who will probably will be taking injections, who will be on drugs and all of those things. So if you have any pressing health concern now, it's better you attend to it. Do not delay it until that time, right? Because you hear so many people's stories, not because they did not read in law school, it's not really because they were not serious, but there are so many factors in play, the God factor and all of those things. So you know anything that is in your capacity to prevent that can hinder you, like your health, please attend to it. So the second one is reading or studying in isolation. Like law school is not something you can do on your own. At this point, you should be having conversations with your friends, with people, your seatmates, exchange ideas. That's the only way you can keep what you've learned fresh, right? Sometimes when you are in the hall, what comes to your mind may not be what you've seen in your books. It may be something your friend told you, maybe over the phone, or something you overheard in the store, all of those things. So you really cannot tell what knowledge sticks. Personally, for me, my corporate law, most of the things that were coming to my head were my lecturer's voice, Dr. Egbe, where she was screaming, do this, don't do that. You want to put your dates here, you want to do this, all of those things. So you really cannot, you need to voice out what you've been reading. You need to say it out to people to make it fresh. And the third one is herd mentality. Don't do things because people are doing it. Don't say because now people are already doing overnight reading. If you're not doing 24 hours reading by this time, you're wasting your time. No. If you've found any style that has worked for you all these previous months, that you've been in law school and it's still working for you, don't dump it because everybody is tilting towards a particular style now, overnight reading, if you know it's going to cost you so much. So the next one is not attending or participating in pre-bar or revision classes. This is a very, very fatal mistake that you do not want to miss, because by this time, your questions are already written wherever it is that they kept them. It's the same lecturers who have gone to Abuja to set your questions. If we don't come and do pre-bar and revision for you, and in those classes, they will stress some things that even you will be like, the way this man is stressing this thing, he has to come out in the exam hall. Plus, you even have some some late time corrections. You may have some preconceptions or some understanding of some concepts before now, and then they are debunking it at this time. There's really no time, there's no time limit to what you can learn. Even this night, you can still learn something that you've never heard of before, right? So don't say that by that time you must have been perfect. Some persons will say, oh, they want to go and read, they are not done with their reading, but what you would gain from this activity, these revision classes, is so much. Plus, you also be learning how to answer questions in real time. The lecturers will be stressing. You can imagine what I said, that Obi Okoye was stressing what we should stress, the property law exams. After that time, most persons did not know that you need to touch this, you need to touch that one. They were like, all those ones is ITK, right? That was 2 weeks to bar finals. So then another thing is not reading questions completely before answering. Always, no matter how much haste that you are in, because a simple comma or a simple word, or maybe you've seen a past question in one format, you don't think, because you've seen it's the same parties, you just go straight ahead to answer them. Read them very well. So not having enough sleep before each exam, you need to sleep no matter how little. It is very important, because the brain is not a robot. I mean, you're not a robot. It's only a rested brain that can give you good results. You can read. I know persons who got to the exam hall and then they blanked out, not because they had not read, but because their brain was not just cooperating. So as much as possible, you need to prioritize your rest. So not exercising vigilance when dealing with your answer booklets. Please do not make this mistake. This is something that can destabilize somebody very, very quickly. Always ensure that before you write anything in any place, you look at it. No matter, even if they're saying 1 hour, be 10 minutes more, always look at, confirm they are writing in the right distance before you put anything down. Oh, sorry. Can you hear me?
Yes, we can hear you, Miriam.
Okay. Sorry if I've not been speaking very loudly. I'm literally yelling here, but okay. So now, next item is predicting exam questions or relying on leaked questions. Do not say that from history or from time, measures is to come out in corporate, foreign participation is to come out. They will never ask insolvency. They will never do this. They will never do that. You really cannot tell. For instance, I'll use our set as an example. Most of the questions we were seeing were not precedented in any past questions. It was nothing like, particularly our MCQs. We even had that they had to rewrite it some hours to the exam. And if you've learned of any leaked question anywhere, do not rely on it as, oh, I have to leave every other thing. This is what will be coming out. I'll use our set as an example. Our questions leaked. They changed. They delayed us for hours just so they could change the questions and bring us oven fresh questions. So imagine persons who had already who had already solved answers to leaked questions and we're going in with just that. Next slide, please. And neglecting a course at the expense of the others, please. Professional ethics is not lesser than corporate, is not lesser than property, is not lesser than criminal litigation. Don't think that any course is something you can read the night before and you'll be good to go. No, you need to have built like a consistent foundation for it. Even if, for instance, now I said I read corporate law more than I read any other course, right? So it's because I knew the mental energy that I needed to read corporate law is larger than what I needed to read professional ethics. So professional ethics for me, even though I did not read it like as much as I read every other course, so something that I read as a leisure. Like if I've read corporate law from morning till like maybe afternoon, I read professional ethics that night because I've already known that I've exerted so much brain power. Professional ethics is like a very easy thing, right? So I did not neglect it totally, right? So the next one is relying on someone for answers in the exam hall or allowing yourself to be relied on for answers. Please do not go into the exam hall with the intention that you're going to cheat with any person. Do not let any person implicate you because just a simple stand up for 15 minutes is enough to destabilize you, right? Please, next slide. Advice, breathe. Bad finance is not war. It's not something that is undoable. And then fix your mindset. Have this positive mindset. I made it a mental duty that I would walk into every exam hall with my head high. Like I walked into every exam hall with confidence that what is coming, right? I knew that I already done all that I could do humanly, that was humanly possible. And that if for any reason I get to the exam hall and I'm stranded, it's maybe because Allah said, we're not going to pass this thing, or you not just know this thing. Do you get? So just have that confidence. It will really, really help you, right? If you are going in with a confident mindset, now do away with triggers and negative talk. When exams were approaching, I tried as much as possible to keep to my room, right? I didn't want to be around people who were saying a lot of things like, or being around people who were visibly fidgeting because of exams, because I knew it could trigger my own panic attack. So I was just only seeing my roommates who I knew were also in a relaxed mind or a relaxed state as I am. I didn't want to be walking around the campus, seeing people in very crazy corners, reading, all of those things was like very quick to make me start feeling anxious. The next thing is rest and sleep when you have to consistently over intensity. You don't have to do 100 every day. If you do 70 today and you do 20 tomorrow, next tomorrow you do 30. So it's just important that you are consistent. You don't have to be perfect at what you do every day. So the next thing is keep your support system close, right? So if it's your family, your friends, keep them close to you. Personally, I'm never a fan of motivational speakers or speeches before law school, but if you look at my phone from that period, I had like plenty screenshots of advice, even the one that's not like remotely connected to law school. If I just say that he's talking about perseverance or he's talking about endurance, I just feel like this is also administering to me. I'll take a screenshot, right? So just to do everything that you want to do, just preserve your sanity, right? So then choose your questions wisely and be strategic with time management. Law school is not who read the hardest or who read the longest, is who can beat it with game. It's like a game, right? And if you are armed with the relevant thing, you can do it. You can do it, right? So like I was going to mention something the other time. Authorities, please. Authorities are very, very important, like we mentioned. But then I used to tell people, if for instance, you is not possible to have 1,000 cases in your head for bar finals, right? So the way you can only minimize this pressure on yourself is that if you find any general provision of law or judicial authority, just go for it. I'll give you an example. For property law, right? I did not stress myself with all this PCL, CA, and then Lagos laws. In some instances, when I have judicial authorities, when I know that it's the same principle that Okafa and Okafor is saying, that's what is in this thing. And I know that if they set the question in Kano or no, in Abuja, in Ibadan, or in Lagos, this same Okafor will apply. So it's the same thing with criminal litigation too. If, for instance, there's a judicial authority that covers the field in that instance, just go for it. If you have statutory, if you do not have judicial authorities, like maybe in arrest warrants and the likes, you have police acts, all of those things, just take police acts. Police acts will apply everywhere. Unless when you have like peculiarities that there are distinct, maybe there are different positions. For instance, maybe death sentence now is different the way they say it in Lagos, in Abuja, in Kano. So there are different authorities you have to learn for that. So it's just about just being distinct. And then for some topics, you see that some cases are like central to those topics. For instance, you cannot talk about power of attorney without talking about Ude and Wara. So it means that nearly every question or any principle on that point, Ude and Wara suffices. So why do you have to stress yourself with some other ones? It's not really about who learns the most cases, but who can make the most of what you've learned. Some cases are universal. That's why I would always like advocate for people to read up cases. When you read cases, you see other instances that it can be used, even beyond what your lecturer has given you, right? So next slide, please. I think I'm done, right? So I'd conclude finals is in the weeks that lead up to it, and the uncertainty that shrouds it, not the exams itself. It is this period that you are in. That's the real problem. That's the real stress. I left every exam hall feeling like, oh, this was so simple. This is what I've been stressing over. Do you understand? So when it is only this period that everything is feeling like you can't do it, you cannot do. When you see your question paper, when reality sets, you even be like, is this why I did not sleep last night? Do you get? And then bar finance is one of the easiest exam you ever write if you believe it to be so. Right? It's just a mindset thing. If you're already scared of bar finance, it's just not possible. You're not just being the mental. You may know something, but because your fear will cloud your mind, you'll not be able to read and interpret questions very well. And then lastly, you are more ready than you think you are. Thank you so much.
That was really, really insightful, Miriam. Like, really super insightful. You are more ready than you think you are. And that's so true because, just as Miriam said, before the exam, you think, oh, I don't know anything. But when you see the questions, you'll be like, thank God. And afterwards, well, I didn't feel that way after my civil litigation because I didn't finish. But we thank God it ended well. And Miriam has just taken us through, different things. Don't fret, mindset, practice, authorities. Also, while practicing, I'll just add, practice with your authorities. So if you're answering past questions, answer and start including your authorities. Because what happened to me in criminal litigation, I answered questions. I think they asked us something about cross-examination or questions to ask in cross-examination. I answered and I forgot to include my authorities. It was when they were saying, oh, time up, and I was just flipping through the pages and I wrote this and I could not see a section of the Evidence Act. I was like, no way. I know this section, I must include it. So, try practicing ahead of time. And I cannot overemphasize attending lectures at this point, close to the exam, revision classes, pre-bar, because when they go to Abuja for that meeting and come back, everything they tell you now will just guide you towards bar finance. So sometimes they will even tell you that, oh, you recall that in week 5, we told you a director cannot do this, or we told you this. Please note that this, you'd see them come back and clarify points like that. So, in fact, one of my mentees in law school sent me a message and he said, oh, David, I think you told me during close to bar finance, you stopped attending lectures. I said, I cannot. So, close to bar exam, very important. Like, go for those revision classes. Now, we've had a very impactful 2-hour session from different panelists. We heard first from Thomason, then to Daniela, and now Miriam has, just wrapped everything into one. Power moments, mind blowing. Would like to hear from the participants. So, just some sort of a commercial break to hear from you. We've been speaking, to hear questions that you might have. So if you have questions, please make use of the chat box. Type your questions as quickly as possible. We still have our panelists here so that they can answer your questions. Thomason, I can see Thomason on the call. I can see Miriam on the call. And, we're supposed to have Benedict and Vanessa, but we won't be having them at this point because Benedict has an appointment that just conflicted with this call. But you've not missed out because we'll definitely get to hear from Benedict via Young VIP TV. If you check the Young VIP TV LinkedIn or YouTube page, you see that he has even done an interview there. So you can hear from the BGS of the backlog set. So if you have any questions, now is the time to make use of our chat box. Okay. Yeah, Favor Samson. Thank you too. Thank you. I can see that Benedict's interview is on the chat box. If you're not following Young VIP TV on LinkedIn, on YouTube, here's a free chance for you to just click the link and watch his interview. Just to confirm if there are questions. So if you have a question, you may raise your hand and unmute so that we can hear you, because I presume typing your questions might be so nuanced that you may not be able to type as quickly as you can, as you'd like to rather. How important is duties in ethics? I don't understand that question. Do you mean like duties of some of those regulatory bodies? Ahmad, is that what you mean? Duties in RPC. Ahmad, do you want to unmute and speak so that I'll get perspective to your question? Okay, while we are waiting, Ahmad, I'll come back to your question. Okay. Ahmad, I'll get back to you. Someone's asking if we can get recording of all the sessions. Yes, that's possible. Check Young VIP on LinkedIn and on YouTube, and you'd see that even previous sessions are available on social media. Please, how did you handle fear leading up to this period, especially for those feeling we had not done enough? I think Miriam would take Samuel's question. Yeah, and then Thomason will take Blessing's question. So while Ahmad, are you ready to speak now? Just quickly, because we are pressed for time. And apologies, this session was supposed to end by 7 p.m., but we'll just extend by a few minutes. Just bear with us.
Hello, good evening.
Yeah, good evening. We can hear you.
Thank you to all the panelists. Interesting session. The question was on the lines of duties under RPC, like the various duties of legal practitioners. Like there's this, like a lot of people make it a course of action to cram the entire RPC. So the question is just how important actually is it? Like, is it sufficient if we just know the the general principles, basically what a lawyer is supposed to do, and not rather than word for word cram the entire RPC. Thank you.
Okay. Yeah, important question. And with regard to cramming RPC, I don't know how possible it is to cram word for word everything in RPC. Some persons did it while we were in law school, but we're close to bar finals already. So my approach to RPC was to understand it, like know the reason why are they asking a lawyer to do this, And then I read the rules whole sub. So I did not just read rule 15 sub 1. I'd read and see that, oh, sub 2 says this, sub 3 says this, just to understand. Because, for instance, the questions in prophetics can be as tricky and as dicey as anything. So yeah, there are some rules that you have to cram. I mean, who does law without cramming? My theory anyways. But first understand. And you can't say something is not important. So far as it's in your curriculum, it is important. Law school can set anything. Miriam said it. Our bar finals, they did not repeat the usual past questions. When we wrote MCQ, some of us gave up on first class. I was like, oh, let's see what we can do. Let's just manage and graduate. So don't think anything is not important. It's important. You don't know who is setting the questions. There are 7 campuses, over how many lecturers. So for RPCs, just try to understand the rules. I know it's difficult, but it's possible. So many persons have done it, and you too, you can do it. That's the mindset. Sorry, I was muted. That's the mindset we're talking about. Then to Miriam, I was thinking you'd help us answer this question from Samuel. It says, please, how did you handle fear leading up to this period? Especially for those feeling we had not done enough.
All right. So for fear, how do you handle fear leading up to this period? I feel like it is very human to feel fear at this time, right? Because of the way everything is going. But the good thing is that you just have to realize that fear will not help you much at this time. I don't know, maybe for me, I don't know if it happens with every other person. I get, when I was in law school, I had panic attacks a number of times, right? But then I realized that every time I had any session of panic attack that I used to be useless throughout this period. It could last for 5 hours, sometimes even up to half a day, right? So that I'll just be like, oh, Mariam, you've not done enough. Mariam, are you doing well? Are you doing this? Are you doing that? But then when I realized that it wasn't helping me, because instead of this panic attack to push me to read even more widely, it was hindering me or restricting me from, doing what I'm supposed to do. So at this time, right, what you just need to do is to just have faith in yourself and in your God, right? Just surrender at this point that you've done your best, you are doing your best. If you genuinely know that you cannot do beyond what you are doing at the moment, right? Just leave everything to Him and just do your thing, right? The good thing about law school is that law school is really, really not, like I would say, it's not something you do on your own strength. If I'm to recount my law school experience from day one to the end, there have been several times that some events will just happen and I'm just like, no, there was no way this just happened as a coincidence. This was God knew what He was doing when He did this for me, right? So I'll just tell you that just fear is human, right? But do not let it consume or control you, right? So if you feel like you're not doing well, if you know within yourself that you're not doing well, so self-evaluate and then see, is there anything you can do more to be better? Is there anything you can do to help yourself? Do you need to speak to people? Just help yourself in those regards and leave everything to God, right? Sometimes some persons go to the exam hall and then they see the question, and then the question one happens to be the last thing they read before they went into the hall. Something that ordinarily they may not have averted their minds to it. Do you get? God works in mysterious ways. Do you understand? So just know that this is not really, really a battle for you alone. Channel your fear, channel it, or do not let it consume you. Just do what you have to do at the moment. And then the thing about all these things is that is you. Personally, I felt like I had not done enough until I saw my question papers, right? So just facts, courage and confidence, all of those times. But once I saw my question paper, then I knew that Mariam, you really, really covered the field. You can conveniently answer the 6 questions. So just a matter of which one do you want to do within these 3 hours. Do you understand? So if you're feeling like you've not done enough, it may just be your own thinking until you see reality. That's your question paper before you see the extent to which you've prepared, right? So I hope that's helpful.
All right, thank you so much, Miriam. Then, Thomason, we have a question from Blessing that says, please, how do I read what was taught in a day and still prepare for the next day in law school? Thomason will be very grateful if you could paraphrase with an answer on that, on Blessing's question.
All right, so thank you. So I think it's a pretty straightforward thing, right? So when you are like back from class and you are freshened up and you rested a bit and you've eaten something like that, so probably around like 5 or 4 you start reading. So for me, what was taught in a day, I don't think it takes me more than 3-4 hours to like read what was taught that day, right? Because I've paid attention in class and I've read before the class, so it's more like I'm just trying to, reread what I've paid attention to already in class and I've read before the class. It doesn't take me more than 3 to 4 hours. So let's say around 9, 10, I'm done reading what I learned for that day. Basically, sometimes I even practice questions.
Okay, thank you so much, Thomason. I heard that you said you read, you try to read, because I don't know whether it was my network, but I struggled at some point to get you, and I can't see that Thomason is on the call any longer. But Daniela, we have a question from from Kati. Daniela, I'll ask you 2 questions from Kati and Kamsi Yochuku, and then I'll circle back to Mariam for the question from Elizabeth. So, Daniela, Kat is asking, is it advisable to start reading now for those going to law school next year? And I understand we have a batch going to law school in February next year. So you may want to answer that, alongside Kamsi Yochuku's question, that are there any tricks on remembering procedures in corporate? So Daniela will be very grateful if you could just help us answer these questions briefly.
Okay. So good evening, everyone, once again. So for the first question, what should I read before going to bar? For me, I always say something. The rule is do what works for you. But for me and for people that have read, that my friends and their feedback, there was no point. So the thing is, yes, you can. For me, I focused on enjoying my life. If possible, I was enjoying ahead of the times I will suffer. Enjoy. I don't know. I just have this image. It's like Jesus Christ going and practicing how to carry the cross before he carries the cross. It's possible. He was already practicing it in his heart. But like, I feel like that's just killing yourself twice. That's my own opinion. And like I said earlier, I don't know how to read before the class. I feel like what's the point of teachers if I'm still reading before the class? I might as well just teach myself. So because of the way I am, I use that period to rest, to relax, to enjoy, to do all the things I wanted to do. I still did those things in law school, but I mean my priority has shifted. So, and I got many advice from people saying rest before you go to law school. rest, do what works for you, do what you've been doing from uni days, if that worked for you. And it did for me, because I mean my result could show. But I'm not of that opinion. Like I said, it still boils down to what works for you. I know people who were slow readers, and because they were slow readers, they were just of the opinion that, okay, you know what, I am going to start reading ahead of the class, so that when people. But my own question now is, if you have read finish now, you enter class and they say what you read is not correct, you will not start training your brain to unlearn it and then start relearning. So to each his own. That was my slogan: to each his own. What works for you, do it. Then for the second person, the question was how to retain procedures. One of the tricks they taught us in law school was incorporate most of the procedures. For example, they're saying change of name, change of object. The beginning, or at least 4 or 5 of the procedures are the same across board. So all you need to do is highlight what are the differences. So I work with a chronological brain where everything has to follow the other. But then also is that for you to easily learn everything together, you need to just identify, okay, if I'm doing change of name, I need if I'm doing change of object, I need special resolution. If I'm doing this, I need this. Do you understand? So that was one of the fastest way for me to learn the different procedures to be able to draft my corporate procedures. So that was basically it.
All right. Thank you so much, Daniela. Miriam, we're coming back to you because you mentioned that isolation while studying isn't good. But what about people who learn better alone? That's a question coming from Amiola Elizabeth. It would be helpful, Miriam, if you could just touch on that briefly.
Okay, I don't know. Maybe it is my choice of words, right? So personally, right, I do not do well with group studying. Like having a group of persons where you sit down and you're like, okay, let us read this topic, and this is saying this is saying that. That's not what I meant in this instance. I'm talking about at this point in time, you should be conversing what you've learned with people rather than just keeping it in yourself. It's different from learning. I studied in the strict sense. I studied alone. I never had a study group, so to say. But I had people that I was studying with. I had like friends from different campuses, friends in my own campus, my roommates, that if I met them maybe on the road, I could just ask a question and I'll ask them to ask me questions, or I can just call my friend and then I'm just like, do you know this? Do you know that? Do you know that this is this? I'm just saying that you need to express what you've read. I'm not saying the actual learning should be done in a group. If it is not your thing, that's fine. It's not my thing as well. But I'm saying you have to converse what you've learned, because sometimes what sticks may not be something you've read in your notes. It may be something that somebody said to you, something somebody corrected you. You know the way the mind works is very, very funny. Personally, particularly in my corporate law, I keep saying it. I was hearing my lecturer's voice and my friend in Lagos campus. I was hearing her voice. The both of them, I was hearing their voices in my head when I was writing, saying this and saying that. Sometimes although sometimes I could visualize my own book, but then the auditory learning also helped me. Do you get? So that's what I'm trying to say, not group study, like a group of persons going to a particular place to sit and study.
All right, Miriam. So there's a follow-up question for you on what tricks can help in remembering procedures in corporate law. Recall you are the best in corporate law in the November 2024 bar final. So just clarify for Kamsi Yochuku, what tricks did you use to know your procedures and all of that?
Okay, so for procedures, right, I struggled with procedures so much because there's a whole lot to learn in corporate law particularly. So what I did then was to isolate them from my general readings. So for my procedures, I had this, I let's say an A4 paper, I'll fold it into two, right, and divide it. So I'll write, let's say, procedure for changing from private to public. I'll write it out. That's one A4 paper. Then another folded or half A4 paper that I'd already like splitted. I'd write another procedure. So I did that for all of my procedures. So I could have them separate from my notes or from my online material. So those ones were things that I read every day, every day, every day. I'm not going to lie. It's not like I perfected everything until the exam hall. And it may not even be humanly possible to perfect everything in corporate until the exam hall. But the goal is that you do not stop trying until you get into the hall. So sometimes you read, particularly for post incorporation, I would read everything. I'll feel like, oh, I've known it. After a while, I'll forget. But then I'll go over. But I think one thing that particularly helped me was seeing them outside my notes, seeing them in leaflets, so to say, that I could just pick up easily and just read and put like more like postcards. I don't know if you get. So I'll just see it, read, put it down, pick another one, read, put it down. So isolating them from my general reading really, really helped me. And then it wasn't like I perfected them, like I said, until the examination date. I kept reading them over because the way the human brain is wired, law school information is much. So if you are reading and forgetting, it is very understandable. It happened to the best of us. It happened to me as well. But the good thing is that you do not stop reading. You continue trying until you get to the exam hall. I'll give you an example. For instance, now I struggle so much with foreign participation. I'm not going to lie that it was that morning, what's it called? That morning of corporate law exam. That was the first time in my life. Although I'd already like read it previous times, but I still did not get it. I was reading those pioneer status, all of those things, and it was sticking. Sometimes when you carry some things like very fresh and like, let me just go to the exam and just go and pour it down, it's better. So if anything is stressing you now, just set it aside. Continue to read it over and over. You can then do a last minute reading the morning of the exam or the night before the exam. Just carry it fresh and go and write your exam. So I hope that is sufficient.
Thank you so much, Miriam. And thanks, Daniela. Thanks, Tomison. I think if we're to talk about answering bar finance question, we won't end this call. But Tomison, Daniela, and Miriam have done an excellent job with addressing, different ways, from MCQs to essays to draft. They've done everything they can. They've given as much information as possible. And I'm just grateful to all the persons that have stayed on this call up to this point. I know you might be scared. Oh, but finance is next month. I don't know my procedures. I don't know my draft. But if you've listened to all what the other panelists have said, we're just like that. We weren't so sure, even until the day of the exam. For me, even after the exam, when I saw first class, I was like, are people serious? When I saw my name among prize winners, I say, what is going on? So we felt the same way. But just as Miriam said, you are more ready than you think you are. And if at any point in time you feel down, you can just go to Young VIP TV and, listen again to the stories of some of the best students that have passed bar finance very well. And you'd see that your experience right now is similar or even the same with what they went through while in law school. We thank the founder of Young VIP TV, Tolu Lokpe, for this brilliant initiative. I thank Young VIP TV because Young VIP TV was helpful to me while I was in law school. And what I wanted to even point out, for all of you that are on this call, you're doing the right thing because last year, we attended webinars like this. I would jump on calls and listen to Nyeru, listen to Joshua Chizoma, and all of that. And you're doing the same thing, which is why we know that next year, we'll be hearing Red Scrolls and you would even reference webinars like this. So I still extend deep gratitude to Young VIP TV. Sincere gratitude also to all our panelists. You can still reach out to the panelists after this call. You can reach out to Miriam, Daniela, Thompson. You can reach them on LinkedIn for guidance and make good use of this opportunity. And I know them. I know they are very willing and ready to assist. You can also even send some of your answered questions to them to preview or to mark and guide you. So with this, so I don't know if you have any final words for us, but we have come to the end of this session, and I hope to see testimonies of Red Scroll and awards from all the participants on this call. Good luck to everyone and good night. Thank you for joining.